Thank you for joining us today. The Legal Services Staff section would like to thank the NCSL Foundation for State Legislatures for providing an e-learning grant to produce this webinar. I'm pleased to announce that over 130 legislative staff and 2 territories are participating today. As always, we will save an archived copy of the webinar and a PDF of the slides on the NCSL website within the next week. Good legislation depends on solid definitions that allow the reader to properly interpret meaning, especially if undefined terms can be misunderstood. Our speaker today is Angela Alexander. She is a senior legislative counsel with the Texas Legislative Council. She was also one of the 4 chief revisors of the Texas Insurance Code. Welcome, Angela.
Thank you so much, Kay. So this presentation, it is based on an in-house presentation that I have given as part of our new attorney training program that we have here in Texas. I have modified it for a multi-state audience, and it is very much an introduction to legislative drafting topic. As part of preparing, I did look at some of the different states' drafting manuals to see how they treat the topic of definitions. Many of those drafting manuals are posted on NCSL's website, so they are a good resource for finding out how the different states do things. I did see a lot of similarities in some states to what we're doing in Texas, but there's definitely variety out there, and there are some significant departures out there from what we're doing. So for that reason, I do want to state at the outset of the talk that your state may have different practices than some of the things I'm describing to you today. So you will certainly need to know and observe the technical and style matters that apply in your own state. I'm not here to upend anyone's drafting conventions. The goal for me with this talk is to help you use this particular type of statutory provision, the definitions provision, for its intended purpose and to its greatest effect. And I want to encourage people not to use defined terms in the statutes reflexively or as a crutch when some other drafting technique might serve better. So that's one of the things I'm going to talk about today. That's going to be one of my main themes. There are several things I will cover. The first thing is a little bit about format and structure of definitions provisions. Then I'll talk about why we define terms in the statutes, how you determine whether or not you need a definition for your term, some types of definitions that we use in the statutes, and the uses and functions of definition provisions in the statutes. I'll talk some about defining terms by reference. I will cover the topic of substantive and artificial definitions and why those types of definitions should be avoided. I will give you some alternatives to using defined terms in the statutes that may, in some circumstances, serve better. And I will finish with a couple of tips and best practices at the end that I would like you to know about. The format and structure. First, I'll talk about placement. Many states, including Texas, will put their definition provisions at the beginning of the unit of law to which the definitions apply. We have a couple of exceptions that are rare if there were short title or findings of purpose provision, but we don't draft those as a matter of course. Those would go first, but usually the definition would be the first thing if it exists. There are a few states that, it's my understanding, prefer to put their definitions provisions at the end. And the other thing about placing them is that you want to usually put the definition close to the smallest unit of law to which the definition applies. So if you have a term that's used in a single section of a larger chapter, for instance, it is perfectly acceptable to define the term in that single section, even if you have a general definitions provision at the beginning of that chapter. For definitions that are going to apply throughout the chapter, you don't have to take your definition out and put it there. It's often more convenient for the reader to have it in that small unit where it's used, and it makes it easier when future amendments are being contemplated to account for the definition when it's located there. If there are multiple definitions that are going to apply in a single unit, they would be grouped in a single definitions provision. Generally for us, that would be a section at the beginning of a chapter or a subsection at the beginning of a section. For your particular definition provisions, the first thing you're going to want to do is specify the unit of law to which the definition applies. And the phrasing we use for that would be something along the lines of in this act, in this code, in this chapter. And then when we have multiple definitions, we would put a colon at the end of that introductory phrase, and we would drop off a numbered list of definitions. They would be in alphabetical order, and they would be capitalized. The term defined would be in quotation marks, and each definitional subdivision would be a complete sentence that would end in a period. Sometimes you only have one definition that you need to incorporate into your definition provisions, and for us, we would begin with the introductory language, and we'd follow that with a comma, put the term in quotes. It would not be in caps because it's not the beginning of a sentence as it is when it's a subdivision. When we use the terms in the operative law, we would not enclose them in quotation marks. And we would capitalize them only if another capitalization rule applies. So just because they're capitalized as definitions doesn't mean you need to keep capitalizing them throughout the statutes. And I would note here there are variations among the states in the type of introductory phrase that might be used to specify the unit of law. I've seen as used in this part for purposes of this act, and I've seen a few states that would prefer to add a phrase along the lines of unless otherwise provided or unless context requires otherwise. Those aren't phrases we would use in Texas, but if it's standard practice for you, then that's what you're going to want to do. I do want to point out that although usually you're going to be grouping these multiple definitions together for the unit of law, sometimes a complex or particularly important definition may merit its own section outside of that general definitions provision. And the benefit of that is that it's going to allow you to divide all the components of your definition up into smaller parts and subparts. In Texas, we do like to break even complex sentences down into subparts, but once it adds readability, but once you've done that, you can't follow that broken up sentence with another unit. So having a single section where you can create subsections and cover separate elements of a definition can be very helpful. If we do it, we usually would lead with a general definitions provision if it exists, and then we would follow with the specific definition with the term named in the heading. Some states might prefer to put the specific definitions first and then follow with something called other definitions. That brings us to the question of why define. The two main reasons you would want to create a definition in your statute is to provide clear meaning. When a term is ambiguous or its meaning is otherwise unclear, or possibly there's a definition that applies to the term that is just not what you want for your purposes, then a definition can establish the clear meaning of the term as it's used in the provision you're working with. Another very common reason to create defined terms is something we call drafting convenience or drafting economy. And that is a use that allows you to avoid the burdensome repetition of the substance of the definition, makes everything a little more compact. There are some other uses that you will see from time to time for definitional provisions, but I would say that these two reasons are the highest and best uses of a definitions provision in the statute. There are two different schools of thought that you will see if you look around at different authorities on drafting. One is what I'm calling the less is more. Our own drafting manual in Texas cautions us that one of the greatest abuses of definitions is their overuse, and quite rightly points out that if the meaning of the term is clear without a definition in the context in which it's used, then you don't need to define it. There's no reason. Reed Dickerson, who has drafted a couple of popular legislative drafting and legal drafting treatises, points out that it's apparently easier to use words properly than to define them accurately. On the other hand, there are some authorities I've seen who would say more is more when it comes to definitions, and they point this out because definitions, they feel, are an important tool to ensure legislative intent is observed by the courts, and that a well-crafted definition will leave less room for a judge's discretion. Some people view the legislative drafting craft as sort of an adversarial process where you're trying to outsmart the courts, which can be important. You want the legislative intent to be observed to the extent you know what it is, and normally you're going to want to cure ambiguity to the extent you can see it. I would also say that definitions can be helpful when you're thinking about the people who are implementing the law or people who are affected by the law. I think it's good for people to be able to understand before a judge has to tell them what the law is actually meaning. So those are two different points of view. I'm not sure they're inconsistent necessarily, but I would caution you, when you feel like you want to use lots of definitions, just know why you're doing it and be careful. Don't define things for the sake of defining them. So there are some different factors you can look at to help you determine whether or not you need to define a particular term. And generally speaking, you would not want to define the term if it has a commonly understood meaning that you can identify, or the context in which you're using it is going to make the meaning clear. If there's an applicable definition of the term that's already in the law and it works for your situation, then you don't need to define it again. You don't need to reference the existing definition. It should just do its job. Sometimes you'll want to consider if there's a better alternative to defining a term that's more effective or efficient. Then, of course, you would want to define a term if there's not a single commonly understood meaning. Perhaps it's ambiguous. It's not going to be clear from the context. In some cases, the meaning of a term may be reasonably clear, but perhaps the boundaries of meaning are not quite clear enough for your purposes. You want to clarify that something's included or not included. You can reasonably expand or contract the boundaries of meaning with a legal definition. And then, of course, if you know there's a definition of your term that you don't want, then you're going to have to craft an alternative definition that will apply to your particular unit of law and supersede that existing definition that won't work. So, factors when you're considering whether something's commonly understood. It is appropriate to consider the audience to whom the statute is primarily addressed. And by way of example, I can say that when I'm drafting insurance regulatory laws, and I'm not talking about consumer protection type laws that your average person might need to know about, but things like reinsurance or investment of insurance reserves, then the main people I'm talking to are insurance regulators, insurance companies, lawyers for insurance companies. And so there are terms in the insurance context that are really technical meanings that are understood in context, terms of art, and you don't need to maybe go overboard in defining them. On the other hand, if I were drafting a statute that governs the relationship of a homeowners association with individual owners, then you're going to be addressing people from all walks of life. It's going to be very important to them to figure out how this law works. And so a little extra effort to bring clarity there is going to be warranted. I wanted to give a couple of examples of some terms that might be commonly understood. Once upon a time, we thought terms like website and internet were worth defining in the statutes, but at some point, the executive decision was made that these are not terms that we need to define anymore. Everyone knows what they are. And of course, contract, used in its generic sense, has a legal meaning, and in our statutes, we can use it comfortably without a definition. Sometimes context can certainly go a long way. In the insurance context, we use terms like deductible and copayment without defining them. In another context, they might have another meaning or be ambiguous. Lot is a term that is used in at least 3 different senses in our law. In the real property context, when we're using it in its generic sense as a parcel of land, we won't define it. In the sale of goods context, in our commercial law, there is a definition of lot for the purposes of a sale of goods, a lot of goods. And then in the elections law context, there's some talk of casting of lots or drawing of lots for certain purposes, and in those laws we do not use definitions either. So knowing where to find existing statutory definitions that may apply to your law is going to be important. Many of you will have construction of law statutes that will include definitions of different terms that are going to be used throughout your statutes. And those definitions will apply, broadly to all of your statutes. So it is very important to know what those terms are and when you need to vary from them. Also, never forget that any unit of law you're working in may be a smaller part of a larger unit of law, which may itself be a smaller part of a larger unit of law. So each of those larger units of law may contain general definitions that would apply to the unit you're working with. And so just be sure you've looked for those and understand what they are. And rarely there may be some definitions in your law that apply outside the unit of law in which they appear. In Texas, we have general provisions in our penal code, including a lengthy definitions provision that by one of the sections in the penal code would apply to any offenses that are drafted outside of the penal code. So that's important to know. If you start reading drafting manuals and treatises, you're going to find a lot of discussion of different types of definitions and find all sorts of ways to classify them and name them. But I would say for our purposes, it can be narrowed down to 3 types that are most commonly used in statutes. Maybe 4 or so, depending on who you're asking. I've seen some distinctions drawn in some of the drafting manuals. But as I've broken it down, I would say the first type is the exclusive definition. And that would be a definition that provides the complete meaning for the term. And there are 2 subsets of this that are most common. Either a general descriptive type of definition, that's a classic definition, or you can have a complete definition that's really just providing an exhaustive and closed list of items that are included within the meaning of the term. In any case, with an exclusive definition, anything that won't fit in the box of meaning that's been provided is going to be excluded. So there are 2 types of partial definitions. And the first of those is a non-exclusive definition. And for these partial definitions, the core meaning of the term that you're using can be presumed. It's not necessarily spelled out. But you use the non-exclusive definition to clarify, expand, or illustrate the core meaning that you're presuming to exist by specifying items that are included. Similarly, you can create a limiting definition, and that can clarify or narrow the core meaning by excluding specified items. And the partial definition is really best used to perfect that generally understood meaning, or possibly a general meaning that's already been given in the statute, without substantially shifting the core meaning of the term, the term's center of gravity, let's say. You shouldn't go too far in expanding or contracting. You'll get artificial. So for each type of definition, there will be magic words that you would use to create the definitional sentence. And in Texas, for our exclusive definitions, we would use the word means. Regardless of whether we're providing a general descriptive definition or an exclusive list of items, we use means. So for instance, the example there, a person means an individual or corporation. That would exclude any other kind of legal entity. For our non-exclusive definitions, we use includes as the verb for our definitional sentence. And for the limiting definitions, we would use does not include as our phrase. The words you use in your state may be different. For instance, I believe Arkansas would distinguish between using means and only includes for certain circumstances. Hawaii distinguishes situations when you use means or includes from situations where you might use refers to. Illinois suggests that when you use the term means to create an exhaustive list of components, when you've got that list, you may need to expressly state that no other components are included. And that brings me to the issue of the phrase includes but is not limited to. In many states, it is not going to be necessary because of a construction of law statute or perhaps a really firm court interpretation to specify that when you use includes, you are not being limiting. Our construction of law statute provides that includes is not a term of limitation, it's a term of expansion. Many states have similar construction of law statutes. And if that is the case in your state, it is rather important to be consistent in not using is not limited to. You'll find people wanting to get you to use it because they want to be really sure. But once the legislature starts departing from that consistent practice, then you raise the issue of whether the legislature really intends to limit the definition when it only uses includes. On the other hand, I have seen examples in many other states where it is seen as essential to state the intent, whether includes is limiting or not. So in your state, it may be important to use the phrase like includes but is not limited to. So that's another case where you'll need to know what the situation is in your state. One other point that's made in many of the drafting manuals is that you don't want to use means and includes in tandem as a complete phrase to form your definitional sentence. That is ambiguous at worst. At best, it doesn't add anything. But, as I show in the next slide, you can use means and includes in separate parts of a hybrid or combination definition. So you can set forth a definition where you provide what it means generally using means, and then go on to say that the term includes a particular item, or you can provide that general meaning and go on to say that the term does not include something. And the combo definition is a matter of supplementing that complete definition formed using means with a partial definition, and you can even triple up and provide what it means, then provide what it includes, then provide what it doesn't include. Or potentially, you could leave the complete definition to be presumed and just provide two partial definitions, what something includes and what something doesn't include. So, as I said before, providing clear meaning and drafting economy are two common uses for definitions. There's also a third use that I want to identify here, and that's the use of a definition to control the applicability or scope of the law. And this is very common, and I would say it's hard to get away from it entirely, especially depending on the context you're working in. There are different views about how bad it is, but I do feel the need to discuss it as a separate issue in this part of the presentation, which I will do. So clear meaning is something that you're going to need to think about. Do words achieve the desired legislative intent? And sometimes the right word choice can make all the difference. You can choose to use a word that perhaps is commonly understood rather than choosing to use a word that needs a definition. But often you will need to clarify the meaning because there's a term that's ambiguous or it's vague. Ambiguity would be a matter of a term having more than one legitimate interpretation, and vagueness means that the terms of application to a particular thing is not necessarily clear. Of course, if your statute is too vague, you may arrive at a place where it's going to be unconstitutionally vague. But in any case, ambiguity and vagueness are usually to be avoided in the statute. However, I did want to point out that sometimes your client will not want to provide too much specific clarification for some sort of political or strategic reason, and will be satisfied so long as the target situation is clearly covered. Sometimes the goal is to give an implementing agency a little bit of room for interpretation in the language, give them the ability to develop more specifics through the rulemaking process. Occasionally, a very broad meaning for a term is desired, beyond the need, beyond what's just necessary for clarification. And often this is accomplished with multiple illustrations of examples that are included within the meaning, and then finishing out with some broad catch-all description, which should ideally be a generalized description of all those items in the list that are examples. What's specifically included or excluded from definitions can often be politically driven, and sometimes it's just a matter of making people comfortable. The general definition or the commonly understood meaning may be sufficient, but people feel more comfortable sometimes when they see the specific item they're concerned about is in or is out. Sometimes people think they know what a term means or that they've defined it adequately, but then when the stakes are high, we find out, well, we're really not so sure what the boundaries of meaning for this term are at all. Litigation can certainly drive the need for the legislature to come back and define terms or redefine terms once they find out where the disputes are. Sometimes you will need to provide definitions for technical terms, and the reason for that is they're not usually commonly understood, and in a lot of cases the audience for the statute is going to need some specifics. The example I've provided here is from our Texas law governing asbestosis and silicosis claims. There's very specific medical evidence that has to be provided to move the claims forward, and as you can see here, the definition of pulmonary function testing incorporates criteria developed by the American Medical Association and reported in a particular CFR, and interpretive standards that are provided by a particular medical publication. So in cases like this, it is not uncommon to have the language for these definitions provided to you. People with the expertise are often involved in crafting legislation like this. But from time to time, you may find you need more guidance. Whenever you identify a need for clarity, for whatever reason that is, try to get clarity on the client's intent. And especially for these complex or technical terms, find out if the client can provide the content for you. In some cases, the client won't be able to define the term for you. They may just want you to craft something that can be considered as part of a legislative process and give people a chance to develop it further. So in that case, the best thing to do is look for models. And in some cases, you may luck out and find something in your own statutes that you can use, or sometimes another state has already legislated on this matter, or the federal government, and you can find something that you can use. Technical glossaries in some situations might even be helpful, or some kind of further research. If you do find a source for a technical definition, I would advise you to inform your client about the source you used. Even if they want to give you discretion in this area, I think the more information they have about how the draft was put together, the better. And the bottom line for this part of the talk is that I want you to remember that the way ambiguity or vagueness is resolved is a policy decision for the client. When you're talking about drafting economy as a reason for a definition, that doesn't involve a policy determination. This is where you are exercising your craft as a legislative drafter to promote clarity and readability with respect to content you've already determined is necessary to the draft. And in these situations, you may even be creating terms for concepts that don't have a commonly understood term to cover them. So this is a place where you can sometimes be a little bit creative. One of the most common drafting economy situations, and it doesn't involve much creativity, I'll admit, is the use of a short form for the name of an agency or official. And it can be very helpful when you have a very long body of law, like our Texas Insurance Code, in which we talk about the Commissioner of Insurance and the Department of Insurance over and over again. We go ahead and put definitions up front in that code so that we can just talk about the Commissioner and Department. and know who we need. If we needed to talk about some other commissioner or department in some shorter part of the law for some limited purpose, then it would be okay to go ahead and just spell out the name of that official or agency. And once you've named that person, you can usually, in that shorter part of the law, refer back to them with that short form if you need to, and the context will tell you who that department is or who that commissioner is. So you don't need to take these out and define them as a short form, in every case. Don't do it reflexively. I will note that I've seen at least one state that disfavors this approach. Oregon, I think, prefers to just name the agency or official at the beginning of each section and then go on to use a short form in that same section and let context control. You can sometimes create what I call an umbrella term, and that is a term that would sweep in related people, items, criteria under the umbrella of one term. And the example here, interested party, with respect to any structured settlement, means any of these listed people here. All of them would have an interest in the structured settlement, even though they're not necessarily parties to the structured settlement. And the adjective interested that's used to create the term captures a quality of all of the people listed here that unites them. And here's an example of using a definition to cover a complex concept that is going to be referenced over and over. This is from our Texas Trust Code, and it creates the concept of the presumptive remainder beneficiary. It's a way of describing a particular type of interest in a trust, and it's really kind of a hypothetical. If certain specified things were to be true on a particular date, then these are the people who would get a distribution from the trust. And so when we go on in the operative law to provide what the trustee can do with respect to these people, the notice that has to be given, we have a short form way of referencing them. This is actually a fairly simple example as complex concepts go. There's actually many more complex examples, but some of them are too big to put on a slide. I think this is a good example of drafting economy, though, and a good example of things that you can commonly do for drafting economy. I do want to talk a little bit about choosing your term and just emphasize it again. When you are creating umbrella terms or terms for complex concepts, try to choose a term that has some sort of connotative value, some sort of descriptive relationship to the content of the definition. And you want it to be an accurate representation of the content of the definition. So I'm encouraging you to not be generic. Don't use a generic term and define it so specifically that it's not really accurate anymore. So a relevant adjective can sometimes make a difference. Some examples here, you see people trying to use contract a lot and define it very specifically because that's what they want to regulate. But if you're really talking about construction contracts or public works contracts, go ahead and call them that and then define them specifically to be what they need to be. And then in our health insurance context, it's become much more accurate for us to refer to health benefit plans rather than health insurance policies, for instance, because these days there are so many different forms of business and types of plans that you can get that are not traditional insurance and they're not indemnity policies. And you don't want these entities to be able to quibble about whether or not they're insured. And it is simply more accurate to call them something that's a little more broad, like health benefit plan. So using definitions for applicability or scope reasons, like I said, it's not uncommon. Anytime that you are specifying a term's meaning, you are controlling the applicability and scope of the law. But you do see instances where it seems like the definition is less about avoiding ambiguity or drafting economy and more about straight up applicability. And as I said, sometimes you can make a better case for it than at other times. I provided an example on this slide that I'm going to break down a little bit. The term insurer is a pretty generic term we're defining here. And we start off with a pretty broad and general definition: an insurance company or other legal entity authorized to engage in the business. Then we go on with this including clause to mention all these specific companies, and these are what I would call must mentions. They are entities that would not otherwise be covered by the law unless they're specifically mentioned somewhere in the law. So this is an easy way, if you want to include these special types of insurers in your law, putting them in the definition of insurer is kind of a clarifying and expansive use that I think is arguably acceptable. And the same thing with making sure that the affiliates of an insurer are regulated to the extent that the insurer is reasonable. But then when you get to the end of this definition, you find out that insurer does not include a farm mutual, which is a very specific and narrow exclusion of one of many, many types of insurers. So while overall I think a lot of this could be justified from the point of view of drafting economy, it is also, I think, an example where you might want to consider if you're too artificially or arbitrarily carving down or expanding a generic term for the purpose of controlling applicability, you might want to consider defining a more specific term or drafting an applicability provision instead. So I will talk a little bit about defining by reference, which is a very common practice in a lot of places. I will mention that it is my understanding that some states have constitutional prohibitions or constitutional limitations that would apply to incorporation by reference. I did not actually see this discussed in any of the parts of the drafting manual that I looked at, but it is mentioned in some of the treatises. So some of the states do have these prohibitions. It isn't clear to me to what extent in all of those states that prohibition might affect the ability to reference within a state's own statutes. But if it is the case in your state, you will want to be aware of it and understand the extent of what you can do and can't do with respect to referencing other laws. In Texas, if we wanted to create a definition that's a cross-reference in a separate provision, we would use the phrase "has the meaning assigned by" as our magic word to create that sentence. If we want to simply reference the definition in the part of the law where the term is used, then we would use a phrase "as defined by" immediately following the term we're defining. So that example, asbestos-related injury, as defined by Section 9001. This is another case where, again, your state may have different preferred wording, but for many of your states, this is going to be acceptable practice. Many manuals advise don't use pinpoint sites when you're cross-referencing to another definition, and that's something we also, that's a practice we observe, because you've got these numbered lists within these sections, and if you cite the specific subdivision, there's a chance that the section will be renumbered. So if you just refer to that section where the numbered list exists, that's going to avoid problems, and it's not going to be unclear where that defined term you're referencing is. If you are looking at a definition that serves your purposes in another part of the law, you're going to want to decide whether or not you're going to cross-reference to that definition or you're going to restate it. So in that case, you're going to need to consider what is the possibility that this definition I'm using will be amended in the future, particularly in a state like Texas where there is a provision in our construction of law statutes that would provide that any of these amendments to these reference definitions will be picked up in the place where they're referenced. In your state, you may need to specify whether or not future amendments will be picked up or not. But in any case, if future amendment is a possibility and you link definitions, you are going to want to consider, are these really closely related operative laws? If the laws are really closely related, that increases the likelihood that picking up those amendments will be desirable. Also, If you have a source law for the definition that is really the primary statute that is associated with the item that's being defined. For instance, we have a state code provisions governing guardianship of legally incapacitated persons, and in a couple of other codes, when we've got some kind of subsidiary or auxiliary law that is providing protections for incapacitated persons in very specific circumstances, referencing that definition of an incapacitated person in the guardianship statute is appropriate. As a technical definition I showed you earlier suggests, sometimes you might want to define a term by reference to outside sources, those AMA guidelines, the medical journals, and these outside sources may be non-governmental sources. But sometimes the legislature is going to want that because they want those professional expert bodies providing detail. They may be the ones who can provide exactly what the legislature wants. Building codes are another good example of where this happens. There are bodies of experts creating extensive codes that are best practices. If you're going to do something like this, you're going to need to know in your state to what extent these references to outside sources might constitute unconstitutional delegation of legislative authority. In Texas, if it is a static reference to an existing version of a source, then that's not a delegation. For instance, the National Electrical Code, as of that date certain, you want that date to be a date that's before the enactment of the law in which you're referencing it. And then what some call ambulatory references, they're either not specifically limited to an identifiable version of the source, or they're explicitly prospective. They want the most recent version of whatever it is. The courts may not accept that. They may interpret it to be static as of the date the reference was enacted, or they may find some reason based on tests that they use that it's permissible or that it's not permissible. And if it's not permissible, they may strike it down. So it's going to depend on the circumstances, and there may be different tests in your states, but be aware of that. In Texas, another potential cure that we often use is to authorize a regulatory body or a political subdivision to adopt future versions of whatever the source is. If we feel it's important to keep current with building codes, we can give the municipal government authority to adopt those future versions, but we can create a baseline with a specific version. You can't require them to adopt these updated versions, but authorizing them sometimes will do the trick. But in any case, if you're not using a static reference, you would want to counsel the client, make sure they understand what the situation is, and if there's a workaround that you can use and that they'll accept, that will be the thing to do. Okay, so let's talk about some types of definitions that you will want to avoid. And this is the part of the presentation that I hope makes the most impact on the way people draft. It's really about how the law should be structured and how to best make it make sense. So the first type I want to talk about is substantive definition. And I would say don't hide the ball. And substantive definitions hide the ball because they're placing what are really operative provisions of law in a segment of the law that purports to define the meaning of a word and nothing more. And it really asks the definition provision to carry weight that the definition provision is not designed for. And it makes the statutes, less accessible and less obvious. People don't necessarily look for some of these regulations in a definition. So some red flags for that. Ask yourself, are you using the language of definition? And for our state, again, means, include, does not include. Those create definitions. Or are you using the language of duty, requirement, authorization, prohibition? If your definition starts using words like shall, must, may not, that's a sign that you're getting into substantive territory. And a prime example of that is on this next slide. It starts out with a perfectly reasonable definition of hospital eligibility system, and it clarifies that we're talking about both financial criteria and procedure, and the eligibility is of a patient for charity care. And then it goes on to provide a lot of different regulations for how that system has to be set up, the criteria it can use, when determinations can be made, and you can see the shall include, may not, may determine. So all of that red text probably would have been better located in an operative provision of law, where people would have a chance to see that it's there. The title of this chapter is Hospital Data Reporting and Collection System. So I think even the chapter heading doesn't give much of a clue that regulations like these would be located there. Some examples are more subtle than that, and you're not going to have that obvious language of requirement or prohibition to tell you that you're going substantive. And I've pulled a great example from the Alabama Drafting Manual. They point out that you don't want to impose a requirement that an agreement be in writing by creating a definition that says agreement means a written agreement. And I know that I've seen this done, perhaps not in our laws, but in language that's been provided to me, and I think I've had to clean it out and put that writing requirement somewhere else. And then in the Arizona example I've given you, that example in part appears to be telling a department when to conduct a particular inspection. And then it goes on as well to impose some sort of compliance requirement with the shall. So these are examples of different types of things to be avoided. One more common practice that I'll flag for you that you would want to avoid is the practice of specifying licensing requirements or other sorts of qualifications for legal authorizations as a matter of a defined term. Sometimes people use things like qualified individual or qualified applicant, and they set out all these qualifications there. And be better served by writing an operative provision along the lines of to qualify for this license, a person must, and then lay those qualifications out. Artificial definitions are another thing to look out for. And Humpty Dumpty from Through the Looking Glass, who you see there on the slide, is the poster boy for artificial definitions. And even the treatise writers love to recall his famous quote, "When I use a word, it means just what I choose it to mean, neither more nor less." And yes, it is true that in the statutes you could define day to mean night, black to mean white, dog to include cat, and it will work. But you shouldn't want to do that, and you really shouldn't need to, because night is a perfectly good word, of course. And so I'm here to suggest that you don't do that. Now, there aren't many such extreme examples in the statutes, but they do exist. It is my understanding that somewhere in the New Mexico law, motorboat is defined in such a way that it means sailboat. So I think that's really amazing. In any case, a really artificial definition is going to provide a meaning for a term that's so far from what any ordinary meaning of the term would suggest that confusion may arise. The example from Minnesota is hospitals includes daycare centers. There's probably some sort of relationship between these two types of entities that you could come up with, places where people receive care in exchange for compensation, but you wouldn't really expect them to be regulated together, particularly in a part of the law where you're only talking about hospital again and again, and where your headings are probably talking about hospitals. So a rule of thumb associated with artificial definitions is that someone reading the operative provisions of the law alone should be able to get a good idea of what the law is about. Even if they have to refer to the definitions for the specific meanings of some of the terms, they should be able to get some sort of picture of where it's going. The problem of artificial definitions, a lot of times in practice, I think it's a matter of just trying to expand the applicability of an existing law in some sort of quick and dirty way. Well, we've got a great law that already regulates hospitals, and we want to do the same thing to daycare centers, so let's just change the definition. But better practices are either going to be setting up some sort of applicability provision that maybe it's a specialized type of applicability provision, but you can say that the law you've already got applies to daycare centers as if they were hospitals, or to the same extent as the law applies to hospitals. Something of that nature is going to be a better, quick and dirty way of adding another person or entity into the law without being overly artificial. If you have more options to sort of draft from scratch, you can just choose a broader or narrower term to define that is going to bear some reasonable relation to the things you're trying to confine in the definition. Or it's always acceptable to just say what you mean, and even if it means amending all of the operable law to say hospital or daycare center shall establish, may provide, then that is, much clearer, and it will take you more time, but in the end you're going to get a better result, and people are going to understand more quickly what the law is about. So I want to quickly show you some alternatives to defined terms. I've talked a lot about the applicability issue, and this slide gives an example of something that people commonly like to do around here. Take a generic term like county and say that it means a county with this particular population. And a better practice for something like that, it would be to set up an applicability provision and provide which counties in particular the law applies to. And I would suggest also that if you're doing something like that, then when you get to the operative law, you might refer to a county to which this chapter applies to cue the reader to the fact that it's not just in a county. And then also you can refer to certain counties in the headings, perhaps. So you're cueing people to the fact that this law is not about every county. You can also define in place in some cases. You can give an illustration with examples, as in that public improvement example I've set out there. It's kind of a long list, but if you only need to do it once, it's not necessarily a bad idea. People can see exactly the sorts of things you're talking about right in the place where you're referring to the public improvement. That second example is one in which you're providing a formula for computing drainable storage in an aquifer, and rather than pulling out the term drainable storage and defining it somewhere else, you can simply lay out that formula in place as a nice, neat clause, and people are going to understand what you're talking about much more quickly. So once you have some specifics in place in your operable law, you will have the ability then, in some cases, to use shorthand references back to those specifics. For instance, you can make a generic term specific by referring back to a contract described by that initial operative provision where you laid out the particular types of contracts that you're regulating. If you need to pick up a complex concept, if it's not a definition, you can sometimes do that by using as described by. For instance, robbery is not defined in that penal code section I've listed there. That's actually the elements of the offense, but a reference to robbery as described by that section is specific to pick up that conduct. And then if you've got a list somewhere, you can simply refer to entities in that list, an entity listed in subsection A1, for example. And then I've got just a couple of tips and best practices to finish with. Searches can be very helpful to you when you're dealing with definitions. For instance, you can search for the term you want to use in your statutes. If you find that it's widely used in your statutes without a definition, you would want to consider whether or not there's a special reason to define it in your draft. It may be that everyone actually has agreed that it has a pretty commonly understood meaning. You may also find by searching an appropriate definition that you can reference or that you can repeat in your law. When you're repealing or amending definitions, keep in mind it's very important to search for the other uses of the term, search for cross-references to the definition in other parts of your law. So that if you're getting rid of a definition, you can make sure that you have conformed the law appropriately. And that can be easy to forget, particularly when you're repealing a large body of law that has definitions within it. But you should be checking and making sure that any other places where those references are used, that they can be addressed. Another general rule you see a lot of times in the drafting manuals, don't use a term that's not used in the law. And you wouldn't think this would need to be said so often, but apparently people think that simply slipping a defined term in somewhere and then not using it does something that it can't really do. Related to that, I would point out the practice of defining terms in your law only to use the term in the text of another definition is controversial, and I think some people would advise you to bend over backwards not to do that. If you're getting to that level of complexity, maybe that standalone definition provision for the primary term is a more useful alternative. And then try to avoid letting the definitions get abandoned, either by repealing or amending operative provisions and taking away all the references to those defined terms that are in the operative law. Or, as you'll find during the legislative process, people start making a lot of changes. What they really care about is in the operative provisions, but they'll forget to clean out the defined terms. So keep an eye out for those things, search your documents, and try to leave no unused definitions behind. So that comes to the end of my prepared remarks, and so I will turn it back over to Kay at this point and see if there are any questions I can try to answer.
Thank you, Angela.
Yes.
Now we'd like to open the floor for questions. If any of you have any questions, please type them in the chat box on the lower right side of your screen, and I will read them aloud. The first question that we've received is, you said don't use means and includes in tandem. How is that different from a hybrid definition?
Okay. When I say in tandem, it would be a situation where you would say person means and includes an individual and a corporation. So it's sort of a compound verb that you're using to create the sentence. In the hybrid definitions, you're using them separately. So means will be used to provide that general broad definition. And then typically, we would usually in a separate sentence say the term includes or the term does not include. So they would be separated, and the content of the definition that's subject to means would be different from the content of the definition that's subject to include. So when I'm talking about don't use means and includes, picture that in quotes, means and includes, as a single verb, because again, it's ambiguous. You either mean something as a complete definition or you're being inclusive.
Thank you. So does anyone else have any questions? I'm not seeing anything in the chat box. So what I'd like to remind all of you is that we will be posting an electronic version of this webinar up online shortly, and we will also post a PDF of the PowerPoint slides so that you can use them as a reference tool later on. I really want to thank everyone for participating in the webinar today, and thank you so much, Angela, for this wonderful presentation.
You're welcome.
This is just fabulous, and we really appreciate all of your hard work to put this together. And thank you all for participating, and have a great day.